from fiction. 2, quell the myths. And 3, extinguish the lies. Affordable housing is a daunting concept to understand and ultimately accept. It is the law. And remember, this is not a Republican issue. This is not a Democratic issue. It is a town issue. And even though I'm a registered Democrat, tonight I stand before you as a committed resident. So please keep that in mind, because we're all in this together. Everything you've heard before is going to be challenged by the experts. And you'll see why we decided to take the course we did. Our first expert, Jeffrey Serenian, he is easily the guru of Mount Laurel. Mount Laurel legend. I mean, when you look up Mount Laurel litigation in any of the Legal Scholar magazines and things along those lines, it's his picture. Okay? Excuse me?
He's not the public.
I'm not on the three-legged clock.
He's not
How
the
come he didn't
public.
do it when he was speaking for 45 minutes?
For the public, the experts and now want get to speak without time limit.
Thank you.
And my view is the public also has no time limit.
Mr. Serenian is a true innovator and champion in the specialty field. He was awarded the status of super lawyer in the field of land use with awards for ethics and service in this discipline. He's a published author who put the definitive treatise of Mount Laurel and the Fair Housing Act on the books in this state. Approximately 70 municipalities utilize his services because of his proven record of success. Experienced, competent, ethical, this master of affordable housing laws leads our team in this difficult issue. But anything further, I present to you Jeff Serenian.
So much later.
Thank you very much, Mr. Lunch. I very much appreciate that. My background is I have been practicing in this area of the law for 36 years now. I had clerkship with Judge Serpentelli when he was a specially appointed judge to preside over these matters. So this is what I've devoted my career to. I've written 2 treatises on this. I represent municipalities all over the state. I've had the choice of representing developers or municipalities. I only represent municipalities. And if it was up to me, the law would be very different than it is. But my job is not to tell you how I think the law should be. My job is to guide clients and make recommendations based upon the law as it is. And so that's what I've done here, and that's what I've done throughout the state. I'm devoutly apolitical, and I don't contribute to anyone's campaign. I want to be appreciated for my
I'm
expertise.
sorry, would you please speak a little louder into the microphone? Please hear from you.
Okay.
Why don't you let him go up to the podium?
Why can't you use the podium?
No.
Madam Chair.
I don't want to do that.
Please don't echo the
Big, big, big mouth. They should ask citizen, not just.
Is that better? Sorry about that. what I'd like to do tonight is, what I'd like to do tonight is I'd like to give you a brief history of the Mount Laurel Doctrine so that you appreciate how all these decisions are made within a certain context. To people who live and breathe this every day, they don't need it, but to most people, this is something new, and it's important to understand the history of the doctrine, where we find ourselves. So the first thing I'm going to do is I'm going to explain to you, give you a brief overview of the history of the doctrine. The second thing I'm going to do is I'm going to explain to you where Englewood Cliffs stands in that history, and then I'm going to briefly explain to you where we are in ongoing negotiations with Fair Share Housing Center and 800 Sylvan, and then I'm going to close with making certain recommendations.
Can I just interrupt you for 1 second? Folks standing, there's about 5 chairs in the front row. Just come on up. You can sit down and be comfortable, and it's getting a little too crowded for safety of the public. So just please come in, please. There's more chairs here. There's a couple down here. If there's a chair empty next to you, raise your hand so nobody sees you, please. Thank you. Come on up, folks. You can leave whenever you want. Once you sit down, you don't have to stay.
Part one, a brief history of the Mount Laurel Doctrine. This whole doctrine started back in 1975 when the New Jersey Supreme Court announced that developing municipalities have a constitutional responsibility to create a realistic opportunity for their fair share of low and moderate income housing. And with that, the Mount Laurel Doctrine was created. In the wake of that case in 1975 called Mount Laurel 1, there's a lot of confusion. What's a developing municipality? What's a realistic opportunity? It was new, there was a lot of pushback, and 8 years later, the Supreme Court revisited this case again in another landmark decision known as Mount Laurel 2. In Mount Laurel 2, the Supreme Court was angry, and they said, in 1975, we announced this doctrine. We expected municipalities to address it and to take it seriously, and nothing has happened. And they said, to quote the Supreme Court, we're going to put some steel in this doctrine, and they established laws that gave developers a great deal of leverage against municipalities. That case is known as Mount Laurel 2. In Mount Laurel 2, the Supreme Court said that this doctrine applies not only to developing municipalities, but even to developed municipalities like Englewood Cliffs. And it imposed a constitutional obligation on these municipalities to address this affordable housing issue. In Mount Laurel 2, there are 2 main principles that you need to understand. In Mount Laurel 2, they created the Builder's Remedy. And what the Builder's Remedy was all about, it was the Supreme Court's incentive to developers to sue municipalities to make them create affordable housing. And then the other important takeaway from Mount Laurel 2 is the judgment of repose. And the judgment of repose was the incentive that the Supreme Court gave to municipalities. Basically what the Supreme Court was saying, if you comply with these laws, if you develop a plan to comply with these laws, I will give you protection from Mount Laurel lawsuits for a period of 6 years. That has subsequently become 10 years, but it was 6 years back in 1983. In the wake of 1983, 3 judges were appointed to oversee this litigation. One of the judges was Judge Serpentelli. He decided the AMG decision in 1984. And what the AMG decision did was it established a fair share formula by which every municipality could create could identify its quote fair share and then try to figure out a way to how to satisfy it. The formula in the case was extremely controversial. It created it started 2 balls rolling, if you will. One ball was it created a movement for a constitutional amendment. And we came very close back in that time to the New Jersey, to a constitutional amendment that would have eliminated the doctrine. But the other thing that it did was it created a movement for a legislative alternative. And that legislative alternative was signed into law in 1985 under the Kane administration. And that piece of legislation has come to be known as the Fair Housing Act, and I'm sure many of you have heard of the New Jersey Council on Affordable Housing, or COA, which is the agency that this legislation created. What the Fair Housing Act did was it said, municipalities, if you want to comply, we're going to create an opportunity for you to comply voluntarily, so you're not subject to developers suing you and seeking builder's remedy. The Fair Housing Act conferred primary jurisdiction on COA and gave COA a tremendous amount of power to establish the laws of the state. And in fact, the court said that that's now the lead agency and the court should take a back seat and COA should take a front seat. And just as the Supreme Court had created the judgment of repose to reward municipalities that complied, any municipality that got a judgment of repose was immune from Mount Laurel lawsuits for 6 years. The Fair Housing Act created a similar thing, a grant of substantive certification, and those municipalities were protected for a period of 6 years. That 6 years period of protection has subsequently become 10 years. But what that meant was that the Fair Housing required COA to come up with new rules, because since the period of protection was limited, that meant that they had to come up with rules for each housing cycle, because it was COA's job that at any point in time, if any municipality wanted to comply voluntarily, there was a body of law with which it could comply. That legislation was vigorously challenged, and in 1986, the Supreme Court decided the Mount Laurel III decision, where the court said, we're happy that the legislature came into the picture. We're happy that they enacted the Fair Housing Act. We're going to defer to the legislature. We're going to defer to this agency that the legislature created, COA. And it's now time for the courts to take a back seat and for COA to take the lead. After that point, COA adopted regulations periodically. It adopted regulations for what we call Round 1 in 1986. It adopted regulations for Round 2 in 1994. It adopted regulations for Round 3 in 2004. Those regulations were invalidated. COA came back, adopted another set of regulations. They were invalidated, and the court said, one last time, you need to adopt these regulations, and if you don't do it, we're going to have to consider some very serious alternatives. What ended up happening was 2014 was the deadline that the Supreme Court set for COA to adopt regulations. They tied 3-3. They didn't adopt regulations. Supreme Court threw its hands up in the air in a case known as Mount Laurel 4 in 2015 and said, it's now time to move the implementation of the doctrine back from this administrative body, COA, back to the courts. And it created a system whereby municipalities that were involved at COA could now start a lawsuit in court, a declaratory judgment lawsuit, bring themselves under the court's jurisdiction, seek immunity from lawsuits under the court's jurisdiction, and attempt to comply in that forum. The court came back again in Mount Laurel 5, a 2017 decision, and said that there was a period of time between the end of Round 2 in 1997 and the beginning of Round 3 in 2015. They said we have to make up for that time, and they established certain laws of what municipalities would have to do to make up for all that time that was lost. So the history of the doctrine teaches us a few things. The law's here to stay. There's no indication on the horizon that there's going to be, there's been a lot of noise, but there's been no concrete movements to change the law in the legislature. And there's no legislative cure on the horizon. And more significantly, there's little hope of COA reconstituting, because there's been over 300 municipalities that have complied in this declaratory judgment proceedings authorized by this Mount Laurel 4 decision, and 280, over almost 300 of them have settled their lawsuits. So the impetus to make changes has diminished. So that's all very significant. So the bottom line is, I could get up here and try to pull the wool over your eyes and say, trust me, the law's going to change in some significant way sometime soon. I don't see that happening. So we got to deal with the law as is. That's not to say you shouldn't try to change the law in the future, but you shouldn't assume that there's going to be a change if, almost 300 municipalities have settled and the impetus for that change has largely diminished. So the question now becomes, where does Englewood Cliffs stand against that backdrop? Let me just finish this.
Can you just give us some perspective? You said 300 municipalities are settled. How many are unsettled or are still fighting it?
But why are you yelling at the public? He's got to finish his presentation. We'll open up to the public after. And I'll answer your questions after.
I promise to answer it. Just write it down if I forget, and I'll make sure I answer it, okay? Okay. So where's Englewood Cliffs in this history? Englewood Cliffs filed a plan in round 2. Remember, we're now in round 3. So they filed a plan in round 2. And in round 2, what COA said, the rules then were, every town gets a number, they could demonstrate they don't have enough land to satisfy the number, and they could adjust their number down. But the portion that got adjusted away, there's a term for it, it's called unmet need. In round 2, COA said you have to take actions to try to address the unmet need. So that was the backdrop. So Englewood Cliffs filed an affordable housing plan in 1995, and it sought approval of that plan. What happened is in 1997, in November of 97, COA said, okay, you can adjust your obligation from 219 down to 4. You have to create a realistic opportunity for your, what they call realistic development potential of 4. And the remaining 215, you have to adopt an ordinance to, it was the Prentice Hall site at the time, and you have to adopt an ordinance at 6 units an acre with a 20% set aside. That's what you have to do to address this so-called unmet need, the 214 that wasn't addressed. And Englewood Cliffs did not adopt that overlay zone on the Prentice Hall site, and they were, in essence, thrown out of COA. And they were exposed to builders' remedy lawsuits. Now, they weren't sued at that time, but they were exposed. Okay, and so what happened after that is they did adopt and file a plan in round 3. Remember, this was in round 2 I'm talking about. So they filed a plan in round 3, and Englewood Cliffs, along with over 300 other municipalities, found itself in Never Never Land because COA was not functioning. COA wasn't processing plans. They didn't have a valid body of regulations. So what ended up happening was when the Mount Laurel Ford decision came along, and the Supreme Court said, we know 300 plus municipalities, you can no longer get your plan approved at COA, but we're going to create this alternative jurisdiction for you to seek approval of the plan. You can move over to this alternative jurisdiction. You can file a declaratory relief action in court, and you can ask the court to give you immunity while the court processes your application for approval of your plan. So Englewood Cliffs did that on June 30th, 2015. In November of 2017, the attorney for Sylvan, I'll call them 800 Sylvan, I just refer to them as Sylvan. The attorneys for Sylvan wrote a letter to the town, and they said, we would like to redevelop our land with 600 units. We'll make 20% of them affordable, and we would ask for you to rezone us. The town didn't respond, didn't say yes or no, and they went ahead and they brought a motion to try to intervene in this case that Englewood Cliffs had initiated when they filed that declaratory judgment action in June of 2015. So, at that point in time, when they moved to intervene, the borough had immunity for Mount Laurel lawsuits. And that immunity lasted till the end of 2017. On December 28th, 2017, right before it expired, Englewood Cliffs made a motion to extend that immunity. Now, before the court could decide that motion, Sylvan filed the builder's remedy lawsuit. That's when I got a call and I was asked, can you help? And the town retained me and I helped defend that lawsuit. I was successful in having that lawsuit dismissed, and I was successful in fighting for Englewood Cliffs' right to determine its own destiny. And so, basically, what ended up happening is Sylvan filed an appeal of the dismissal of its lawsuit. And so on one hand, we're fighting Sylvan in the higher courts, where they're telling the higher courts, Judge Toscos at that time, now retired, shouldn't have dismissed my lawsuit, reversed that decision to dismiss my lawsuit. And on the other hand, we're in the trial court before Judge Farrington, who's processing the declaratory judgment action we brought in 2015, processing our application to seek approval of a plan. So what's happened in the trial court proceeding is the judge has issued, well, first of all, what happened in the trial court proceeding is there was a period of time where the parties sat down and tried to resolve their differences. We were unable to achieve a resolution, and by the end of 2018, we were rapidly moving into a litigation mode. And Judge Farrington basically established a set of very aggressive deadlines and said, well, since you can't settle, let's move forward and let's go ahead and litigate. So we found ourselves racing headlong into litigation, and Judge Farrington made multiple rulings that were really problematic for the town. And it was quite clear that the prospects of a successful result in front of her were not high, to say the least. And so, you know, we were moving forward, and a newly elected council was created, and it was, well, is there a way to solve this without facing the risk of Sylvan, who at that time had filed was seeking the right to do 600 units at one time and like over 800 at the other time. And so we were up against this fight, and the court was quite clearly unsympathetic. And so a series of negotiations began with Sylvan, and ultimately a non-binding memorandum of understanding was entered in April. Now, I emphasize non-binding. And the idea was, let's see how much we can reduce the intensity of how intensely that site could be developed. And then let's make sure we protect the public's right to input. And let's see if we can work out an agreement that we would then present publicly, and then we would have an opportunity to decide whether to approve that or to fight further. It was quite clear to all of us that were in the litigation mode that it was it was a very bleak path that we were looking in court. And it was quite clear that in a court proceeding, we were not going to make out well. However, if we could litigate a favorable settlement, we had the opportunity to take control, to manage how that property is developed, and to insulate the town as best as possible. And just to give you an idea of how far apart we were, you know, we were in a case where we were saying that we had a number of 584. If you look at what the obligation was for the prior rounds and for round 3, that number was 584. And we were saying that we only had enough land to address an adjusted number of 77, and we were in all-out war litigation with Sylvan and Fair Share Housing Center, where they were claiming that the number could be 200 or 300, you know, 3 times what we thought was appropriate. We knew that it was a very difficult, there was a lot of risk involved with going forward in litigation with a court that was not sympathetic to the town. And we entered this negotiation to see what can we work out, understanding that ultimately, whatever we came up with, we'd have to stand before you with a final form of agreement, and your choice would be to settle or to litigate. All the professionals that looked at this, it was very clear. Litigating this was not going to end well for Englewood Cliffs. Through settlement, we had a chance to manage the risk. Through litigation, it was not looking good at all. And so we went down this path, and we've tried to put together a settlement that's still not final, which is why I have to be guarded, and you may have questions that I'll have to say I can't answer, because we're not settled yet. We're still litigating, and unless and until we're settled, I have to be guarded. But while we're going down this path in front of the trial judge, who had set like a January 25th trial date and then moved that because the parties were settling, we are also up on appeal. Sylvan has challenged Judge Tosco's ruling to dismiss its lawsuit. So we're up on appeal. I expect that on August 1st, the appellate, and we've managed to get several extensions of briefing that appeal. I'm expecting to get an order on August 1st that says, you know, you got to get your brief in so much time. And if they are able to reverse Judge Tosco's decision to dismiss their builder's remedy suit, their leverage is going to go up and their demands are going to be much greater. So the bottom line to all this is we're trying to manage the risk that's facing the town. One thing that bears emphasis is not one unit of affordable housing has been created in this town. When you're in a Mount Laurel lawsuit, that's not a good fact. Okay? A lot of developed municipalities have found ways to produce affordable housing. Here we are pushing back. We don't have any affordable housing to show for it. So that's a real problem. The other issue here is one of the problems in this case, one of the problems with our history, and I don't think we should be plagued by it, but our adversaries pointed out at every turn, is we were basically thrown out of color. Because COA said, I'm approving your plan, but you need to adopt an overlay on the Prentice Hall site, and they didn't do that. It's a problem. You know, it's a problem. And the judge, in her rulings in November and December of 2018, the judge was expressing her frustration that this case wasn't settling. Remember, the vast majority of these cases are settling. Englewood Cliffs was fighting, and they didn't have any affordable housing to show. Okay? So it was very clear to us when we started negotiating with Sylvan that if this case gets tried, you cannot expect a good result.